Hello and welcome to day 2 of the PRI Forum Americas. I'm Lindsay Walton, head of Canada at the PRI. If you're joining us today for the first time, please do get involved. You can submit your questions for our speakers via the question tab in the panel sessions. And we encourage you to post your views and engage with us on social media. And please don't forget the hashtag PRI Digital Forum. All sessions are being recorded and will be posted here on the event afterwards. If you're having any technical difficulties at any point, please check the FAQ tab at the top of your screen, where you'll find helpful advice and further contact details. We're going to begin the day now with the topic of human rights, hugely important for investors, but often confusing and difficult to act on. Before we hear from our keynote speaker in just a moment, let's take a look at some of the work PRI has recently released on the subject and some actions for investors.
Every human being has the universal right to be treated with dignity, irrespective of nationality, sex, race, religion, or any other status. These rights are codified in the International Bill of Human Rights and International Labour Organization's Declaration of Fundamental Principles and Rights at Work. The reality, though, is that human rights aren't always respected. This has direct negative effects for people, but can also damage companies through reputational, financial, and legal consequences. Following decades of documentation of private sector involvement in undermining human rights, the UN Guiding Principles on Business and Human Rights were unanimously adopted by member states in the UN Human Rights Council in 2011, and thereby defined the corporate responsibility to respect human rights worldwide. They are a normative standard of conduct and have become the universal, global playing field for companies and investors. In 2013, the UN Office of the High Commissioner for Human Rights clarified that they apply to institutional investors as well. In 2017, following cases against investors in breach of the guidelines for multinational enterprises, the OECD also released guidance for investors on tackling this issue. What does this mean for investors? The UNGPs consist of 3 pillars. The state duty to protect, which emphasizes that governments should consider business entities when regulating to protect human rights. The corporate responsibility to respect, which exists independently from state duty and applies to all companies and investors, regardless of their size, sector, location, ownership, and structure. And the access to remedy, which is an expectation of both states and companies to offer access to remediation for those who have had their rights impacted. In practice, investors are expected to clearly state their commitment to respect human rights, identify, address, and communicate negative outcomes to people associated with their investments, and finally, to use their influence to ensure that access to remedy is provided. How will the PRI support investors to tackle this issue? We will raise awareness and build understanding of human rights among institutional investors. Increase accountability among signatories by introducing human rights questions into the PRI reporting framework. Facilitate collaboration to address industry challenges to implementing respect for human rights. Promote policy measures that enable investors to manage human rights issues. Drive meaningful data that allows investors to manage risks to people. In a renewed effort to address this issue, the PRI has set out a framework for investors to meet the standards set out in the UNGPs and align their investment, stewardship, and policy activities with the expectations of employees, beneficiaries, clients, governments, and wider society. Find out more in our recent paper, Let's All Invest with Respect.
I'm now delighted to introduce one of the world's leading authorities on this subject, the author of the UN Guiding Principles on Business and Human Rights, Professor John Ruggie.
Thank you, Lindsay. I'm delighted to be with you this morning at this forum. And I want to begin by offering my congratulations to the PRI membership, as well as to Fiona Reynolds, your intrepid leader, for launching the landmark human rights framework for institutional investors. This initiative could not be more timely or more important, given the state of our world today. Institutional investors have a significant role to play in addressing the unsustainable economic and social inequalities and other forms of human rights harm built into our current system. The PRI Human Rights Framework provides you with a tool to help secure the social sustainability of a global economy that works for all. My aim today is to put your initiative into the context of a rapidly evolving national and international regulatory system concerning business and human rights in order to underscore your initiative's timeliness and importance. Now, the idea of human rights is both simple and powerful. Human rights belong to everyone. They are not granted by the grace or at the discretion of others. They express the basic dignity and equality to which every human being is entitled. Respect for one another's human rights forms the basis of all sustainable relationships. Widespread understanding and acknowledgement of the responsibility of business to respect human rights is a relatively recent development. To be sure, it was implied in the Universal Declaration of Human Rights, adopted by the UN General Assembly in 1948 as a common standard of achievement for all peoples and all nations. But it was authoritatively established and elaborated only in 2011, when the UN Human Rights Council unanimously endorsed the guiding principles on business and human rights. These are reflected in the new PRI Human Rights Framework. Under the guiding principles, the core responsibility of business is to respect human rights, which means to take measures to avoid the harm to the rights of other people through its operations and business relationships, and to address harm where it has occurred. Now, how can human rights be harmed by business? Let's start with breaches to health and safety in the workplace, of the right of workers to organize, of equal pay for work of equal value, through discrimination, be it based on race, religion, ethnicity, gender, sexual orientation, or by using child labor and forced or bonded labor. The right to privacy can be jeopardized and has been jeopardized by digital platforms, collecting and selling personal data. The right to property, food, water, and adequate livelihood can be undermined by land grabs. The right to security of the person from abuses by security personnel. Before you get too excited, altogether there are only 30 plus human rights that governments have recognized through UN treaties. It turns out that business can have adverse impacts on virtually all. Now, the guiding principles ascribe obligations to governments and business alike. The role of government is to protect against human rights abuses, including by business. The responsibility of business is to respect human rights, regardless of whether governments fulfill their duty. So, how does this relate to institutional investors? I'll make 3 points. First, institutional investors are businesses in their own right. Yes, I know that the category of institutional investors includes university endowments, foundations, worker pension funds, and the like, which may not think of themselves as businesses. But in a sense, when they invest, they are. Institutional investors, to be sure, are one removed from operating companies, but your investments make it possible for businesses to start, expand, innovate, create jobs, and deliver essential goods and services. Therefore, you are linked to operating companies, even if individually, only on a small scale. Under the guiding principles, your human rights responsibility is to use whatever leverage you can, individually and collectively, to ensure that investee companies do, in fact, respect human rights. Second, PRI membership from the beginning in 2006 has required you to seek ESG disclosure by entities in which you invest, as well as to incorporate ESG issues into your own investment analysis and decision-making, ownership, policies and practices, and engagement with investee firms. Now, if you look at the categories used by ESG data providers, most of the elements under the S are in fact human rights issues, with the rest being close cousins. So while the PRI framework may be new, the membership obligation to take human rights into account, embedded in the S, has been there all along, but rarely highlighted in the past. The pandemic has brought it to the fore. My third point concerns the elephant that just lumbered into the room: materiality. No divine being has defined materiality. It is a matter of judgment. As the International Federation of Accountants describes it, materiality works as a filter through which management sifts information. And what gets sifted through that filter increasingly must include human rights. The reason is a combination of fact pattern, practical experience, and law. You know the facts better than I do. ESG funds have performed as well, if not better, than conventional funds, according to the Wall Street Journal, at least since 2015. During the pandemic, on average, ESG funds have seen better relative returns, lower volatility, higher inflows, and smaller net outflows. Because most of the S in ESG is addressed to human rights issues, the scope of materiality objections to considering human rights in investment decisions is shrinking. So what about practical experience? Well, in the past, operating companies often discounted human rights risks as not material, or they looked only at first-tier suppliers, even though that's not where the risk was. Over time, companies have found that the risks they had discounted or ignored have materialized due to the severity of adverse impacts on people In those cases, the result often has been operational and reputational harm to the business and potential legal and financial consequences. Now, the UN guiding principles spell out the human rights due diligence process for business by which to identify, prevent, mitigate, and account for their involvement in adverse human rights impacts. Adopting effective human rights due diligence has helped companies to learn that risks to people can easily translate into business risks. This also enables companies to identify the most severe risks for priority action. In addition to ESG performance and learning from practical experience, the scope of judgment regarding materiality is narrowing because a growing number of jurisdictions are transposing the guiding principles due diligence provisions into domestic hard law. The hardening of human rights due diligence into domestic law began with modern slavery reporting legislation, as in California, the United Kingdom, and Australia. None of these yet impose serious legal penalties for non-compliance. But the French duty of vigilance law, adopted in 2017, goes further. It requires human rights and environmental due diligence of the largest French companies and foreign firms with a significant business presence in France. Civil claims are possible where harm occurs in connection with certain business relationships. In the Netherlands, a new child labor due diligence act applies to all companies that sell or supply goods or services to Dutch end users, regardless of where the companies are registered or based. And it does involve criminal penalties for directors. In the US Customs and Border Patrols has prohibited the importation of goods suspected of having been produced with forced labor, and it is increasingly requiring evidence of due diligence and remediation before the shipments can be lifted, before the halt of the shipments can be lifted. Turning to Switzerland, in less than 2 weeks, the Swiss will hold a national referendum that would impose mandatory due diligence on Swiss corporations based on the guiding principles. Again, civil claims would be possible in some cases. At the regional level, and this is perhaps the most significant development, the European Commission has announced that it intends to propose legislation in 2021 that would mandate human rights and environmental due diligence for companies operating in the EU. The Commissioner for Justice has made clear that enforcement mechanisms, including civil liability, will form part of the proposal. So, to sum up, the positive performance of ESG funds, companies learning from costly past mistakes, and human rights due diligence requirements with potential legal consequences all indicate that human rights issues must be addressed even on the narrowest of materiality grounds. So let me draw these remarks to a close. I have focused on the responsibilities of institutional investors as businesses. You might say that I've made the business case for human rights. But of course, you are also more than businesses. You are stewards for your ultimate beneficiaries. In the case of fund managers, you are entrusted with people's savings for retirement, for their children's education, and for a sustainable future for those who come after them. If you are a foundation, the chances are very good that you have a social mission. As for university endowments, Harvard, where I teach, was established in 1636. Its endowment is intended for perpetuity, not for the next quarterly results. These are all critical stewardship roles. Now, some of you may know of Leo Strine, the former Chief Justice of the Supreme Court of Delaware, where the majority of large American listed companies are registered. In a recent lecture entitled Stewardship 2021, he made this provocative statement, and I quote, "For many years, stewardship has been more a name for the investment industry, blaming those who manage real companies for every problem. When, as a matter of linguistics, stewardship requires something more inward and responsibility accepting. True stewardship involves undertaking meaningful obligations yourselves." So, my friends, we truly are at an inflection point today. The world is on fire, people are hurting, leadership deficits are common. As investors, we need to try something different going forward. Investing as though people and planet depended on it, because they do. So push for global ESG standards. Make sure you ask for and receive high quality data from investee companies and data providers, including on human rights issues. Support mandatory human rights due diligence and practice it yourselves as you invest, engage, and vote your shares. Thank you again for the pleasure of having me join you, and have a great conference.
That was Professor John Ruggie with a thought-provoking message for all of us. We're taking a short break now, and we'll be back in a moment with a session on a very pertinent topic for investors: diversity, equity, and inclusion.